Stacked though. It's almost unfair. All right, so a couple new faces tonight. I think we're sort of started. We all, Matt went to the restroom. When he comes back, should we all make him feel uncomfortable? Maybe not. All right, for people that are online, we got 65 so far. You'll hear the dings. We turned the dings down, so I gotta catch my breath because I almost like ran. I'm a security guy. We don't work out much. You probably knew that. Sit behind a desk all day. And I got kids, so they sit around home too. All right, so I wanted to start off with, got some new faces here tonight. Thanks for coming. You know, hoping I get to know you guys a little bit. We'll go through these things. We also have Brad with us tonight. So this is Brad, doing stuff, our senior analyst. He'll also lead a couple of the classes, or a few of the classes as we, go through things. He's got a family too, so, he won't be here every night, I don't think. He's got other things and commitments too, but every time we get a chance to have you here, it's awesome. Thank you. So I'm glad you're here. Okay, so one of the things I want to start off with was we got some feedback over last week, and I just wanted to share it because anytime you guys send me feedback, it really means a lot. I take it, it comes right to me, and I review it and take a look at it and all that stuff. Just some basic feedback. One was the recommendation that I share with you that this book is available on Kindle, and it's $10 cheaper. So if you like Kindle and you haven't, or you already haven't already bought the paper book, it's on Kindle too. Another one was the dinging, and I think we already took care of that. We've got most of our technical issues, I think, fixed. You're not going to see me fumbling around. I don't have a technical issue slide today because I'm not expecting any. I was expecting last week, so it's all good. So that was the second piece of feedback. And then the third piece of feedback is when you ask me a question, and I do encourage questions. So as we're going through any of these topics, if you've already read this chapter and there was something that you kind of made a note of, you wanted to ask in class, please do that. But the recommendation is when you ask me a question, I'm going to repeat it so that the people online can hear it, and then they can kind of get the context too. Sound good? All right. So today we're digging in, chapter 1, 65 slides. Like I said earlier, we're going to spend about 10 minutes on each slide, so we're going to get done in about 5-6 hours tonight. I could do it. We could do it, totally. Now we'll get done in 2 hours. It'll go fast. You're going to realize really quickly when we get through the material that a lot of this is memorization, and that's true. You just need to memorize this stuff. And so for me, memorization means repetition. That's why I do that 3-time pass on the book. You're just going to need to memorize a lot of this stuff. So whatever it takes for you to memorize these things, that's what we're going to do. So these are the things that we're going to cover. And if you're following along in the book, we're going to follow right along with the book. I might add some context or color to some of these topics to try to make it not quite so dry. I'll add some stories where they come to mind. We're going to start with our cornerstone information security concepts. Did anybody see the definition of information security, my definition of information security in the book? You're supposed to say, yeah, if you read it, I suppose, because it's the same definition, right? It's a good definition, and we just stick with it, right? It's the application of administrative, physical, and technical controls to protect the confidentiality, integrity, and availability of information. And you'll get that just by memorizing it. I say it all the time. People get sick of me saying it, but until people get it, we'll keep saying it. So legal and regulatory issues, which are, to me, are kind of fascinating because that drives so much of security nowadays. And if I understood what security was, then maybe I would manage it differently. But right now, most people manage information security due to external factors. There's a driver from the outside that's kind of motivating me. So we'll get into that. Security and third parties, ethics. Ethics is it's actually one of the most difficult things for me to talk about because I think, I'm going to go on. I think ethical people kind of take that stuff for granted, right? So when you talk about ethics, what does it mean to be ethical? We're going to talk about the canons. When we talk about ethics, which you'll have to subscribe to, and they come in order. There's 4 canons. You have to apply those things in order. Information security governance, access control, defensive categories and types, risk analysis, and types of attackers. You can go as deep or as surfacey as you want on any of these topics. So if you do have questions, I encourage that, and including online. Right now, Brad is also monitoring the online chat window, and we'll keep taking those questions unless it gets like question, then everybody's going to get frustrated. So, all right. Oh, there it is. There's our definition of information security. Administrative, physical, technical controls protect the confidentiality, integrity, and availability of information. If that doesn't, the way you can test yourself is this, and this is just ask yourself, what is information security? And that should be your answer. Once you kind of have that down, and that's a good functional. That's not something you're going to have to unremember. There are things in this test and in this class that you can just forget about as soon as you pass the test. This isn't one of them. Okay. Any questions on this? Do you know what confidentiality, integrity, and availability are? Confidentiality is essentially keeping data secret, right? If you were to use layman's terms, it's making sure that only the people that can access information for the purpose of disclosing that information. Integrity is making sure that the data is accurate. If you want to break down integrity even more, there's two types of accuracy, two types of data integrity. There's internal and external data integrity. Internal data integrity is like in a database, where the data has to be, there's referential integrity. We're going to cover that in a later domain. But then there's also external integrity, and that would be like if my database management system says my warehouse management system says I have 35 widgets, and I go out and check in the warehouse, I should have 35 widgets. Right? If I have something other than that, then that's also an integrity issue. Does that make sense? So integrity is making sure that the data is accurate. This is a really big issue too in healthcare, because PHI, protected health information, one of the motivators for stealing that information and then selling it to somebody else is that if I was a bad guy, I could get treated, for my whatever I'm having under your insurance, right, with your protected health information. Where integrity becomes a really big issue is if you have some kind of disease that I don't have, and then I go get treated at the hospital, they may assume that I have that same disease or I had that disease, and it'll alter the form of medical treatment. Right? That's a really big issue for data integrity. And then availability, making sure that it's available to the people who are authorized to have access to that information. All those have to play in balance with each other for a good security program. So balance is critical. The opposite of CIA, if you're an acronym kind of person, CIA, confidentiality, integrity, and availability, not the other kind of CIA. The opposite of that is disclosure, alteration, and destruction. So it's DAD. So if you're looking for an easy way to remember it, CIA and DAD. Make sense? All right. So PII, so privacy. Do you remember when I'd asked that CISO, this was actually in a breach investigation, I'd asked the CISO to give me your definition of information security and tell me how it differs from that of privacy. That was the question. And I didn't get an answer, a good answer at all. So my definition of security was, or our definition of security was in the last slide. Our definition of privacy is essentially the same thing. It's just confidentiality of one type of data, right? Confidentiality of protected or personally identifiable information, sometimes referred to as PII. So that's privacy, really just protecting the confidentiality of personally identifiable information. Make sense? Questions? All right. So cornerstone, these are cornerstone information security concepts. So that means that if you don't kind of understand this, then most of your other parts of security, I think, will be a little bit off. These are foundational concepts for security. Others are identity, authentication, authorization, and accountability. Identity is nothing more than professing that I'm somebody, right? A username, a user ID. Those are all examples. Those are both examples of identity. Often a name, there's no proof of it. The proof comes from the authentication. That's proving my identity. Social engineers often profess an identity without proving it, right? Asking a social engineer to prove their identity, and that becomes a tougher issue. It's not a stop all, but it does make it harder. And I have an example of that actually. When I was in a social engineering class, and it was at Black Hat. You guys ever heard of Black Hat? If you ever go to socialengineer.org, the guy Chris Hadnaghi, right? He's an awesome social engineer. And he was teaching this class, and one of our homework assignments or tests was we went to this mall, and him and the other teachers of this class, their job was to, they would text me a target somewhere in the mall, and I'd have to go up to that target, and I'd have to find out their name, where they're from, how old they are, and where they work. That was my job, right? Simple enough. So my first target was this. It was texted to me, the lady with the hijab, Hijab. I guess it's the head thing. Hijab, is that how you say it? Well, I didn't know idea what the heck it was. So I'm like, whatever, man. I don't know who this is. Well, then he said the lady with the, the head. I don't know, whatever, sitting on the bench. So I walked up to her and my pretext. So a pretext is basically who I'm pretending to be in a social engineering attack. My pretext was I'm a student at the University of Nevada, Las Vegas, and I'm doing a demographic study as part of my sociology class. And so I'm gathering this information for people that are visiting, Las Vegas. So welcome to Las Vegas. Do you have a minute? Sure. Okay. Give me all your information, right? And so I had professed my identity as this person, but she never asked me to prove it. She never asked me, show me a student ID card or anything like that. That would have, and this is pretty innocent, right? But I noticed out of the corner of my eye, this guy who was walking up towards me, and I was like, whatever. So my next target, I went on to my next target, and then going up to my third target, he stopped me and he said, can I ask you what you're doing? And I said, well, I went through my whole pretext, I'm a sociology student here at University of Nevada, Las Vegas, and whatever. He asked me one question that threw me entirely off my pretext. He asked me, who's your professor? Right? He asked me to prove, that's one piece of proof potentially for my identity, and that threw me completely off and derailed so in hindsight, right, Mr. Jones, Mr. Jackson, just come up with some name, right? But he just froze me. So I told him, I said, all right, you got me, I'm a student, actually at, Black Hat, and I'm going through this class and everything. This is my homework. See my professors over there, and they're, hey, they're waving. And he goes, well, I thought something was off about you. He turns out he was a police officer from New Brunswick or someplace in Canada. So anyway, just professing the identity to a social engineer. And you can do the same thing at work. You see somebody walking around. That's why you were asked to question them. Can I help you? What are you doing here? Well, I'm a new employee. Well, where do you work? Oh, I work in the accounting department. Oh, so you work with Jane? Yeah, there's no Jane there. It's proving the identity that throws them off. So authentication. So authentication identity is just username. It's just stating that I am something. In this case, we're used to it with computers. A username is all you need. Authentication is proving the identity. In most cases, it's a password, right? So the concept behind that is that only one person has that password, and it's me. Nobody else has my password. As long as that's true, as long as nobody else has that password and your identity is actually proven, the problem is people write down their passwords, people share their passwords, people choose poor passwords, right? So we can't guarantee that the password is actually not disclosed. So that's why we don't like passwords. Passwords stink, but that is one method of authentication. So authentication is proving who I am, often a password, PIN code, picture, something. In the case of biometrics, it might be my fingerprint scan, a retina scan, something like that. Identity without authentication is pretty much useless, right? Did anybody else ever notice that, like with social security numbers, we use that for identity and we use that for authentication? It kind of violates a rule, doesn't it? They need to be separate. What?
They stopped having to do that? Because I know a couple of education systems were using it especially.
Yeah.
And they got called out for pretty roughly.
Yep.
It's illegal, right?
No, it's not illegal. Yeah. So, for the benefit of the students online, one of the mentioned that they used to be pretty prevalent. They would use social security numbers. Actually, Wells Fargo, up until just a few years ago, was my username for my Wells Fargo account was my social. Well, what the hell, right? But yeah, it's not happening nearly as much as it used to. But it used to track people, their identities were their social security numbers, and that's fine if your identity is a social security number. But we're not going to use that for authentication, or every time we use that, we're going to use strong authentication for it. That would be fine if I use social security numbers for identity, which is what they're actually intended to do, right? So anyway, identity with authentication is pretty useless. If I steal your authentication, I get to be you, right? I prove to the system that I am you. And so when an incident happens and we go to do the investigation, it looks like it was you. And so you're the one that gets, and if you've said, well, I shared my password with others, well, then now we've kind of lost the integrity of the investigation potentially. So it's really important to keep those different and to keep them safe. So identity authentication, there are 3 types of authentication. Multi-factor, you've probably heard of multi-factor or 2-factor authentication. There's 3 types of authentication or 3 factors. So one is something I know, username, password, PIN, not username, password, PIN, something like that. The other one is something I have. So a key fob, a cell phone, something that's typically physical. And then the third is something I am. Something I am could be a fingerprint scan. It's a biometric, right? So 3 types of authentication. There's actually arguably a 4th type, and that's where I am, but that's easily spoofed, right? So I could use geolocation as another method potentially, or factor of authentication. 2-factor authentication is 2 of those factors. So every time I go to, we do it all the time. Every time I go to an ATM machine, I'm using 2-factor authentication, right? I have to have the card. I slide the card in. I also have to have the PIN, right? So that's something I have and that's something I know. That's 2-factor authentication, right? Common 2-factor authentication now is sometimes it's referred to as phone factor authentication. I type in my username and type in my password and I get a text, a 6-digit code that I then have to type in. That's an example of 2-factor. 2-factor authentication or multi-factor authentication is also referred to as strong authentication. Does that make sense? So strong authentication is 2-factor authentication or multi-factor authentication. You could have 3 factors in authentication, but that's really, really rare. Yeah, and we'll get more into biometrics. We'll dig in deeper in biometrics. We'll talk about the effectiveness of a biometric system, how we measure that. That's all fun stuff. And then authorization. So I identify with the system, I authenticate with the system, I prove to the system who I am, and the next thing I get is rights or privileges in the system. What can I do now? And those are assigned usually, they can be assigned in a number of different ways, but identify, authenticate, authorize. The last part is accountability or accounting. What did I do in the system? That's why log files are, that's where log files come into play and stuff like that. So accountability, a record of what I did, a log file. So this becomes really important. We'll talk a little bit later on today about preventative controls, detective controls, corrective controls. Log files are used for detective controls, right? I can use what's happening in the system. I can use something like an SIM, or if I'm actually manually looking at log files, I can identify that something bad might have happened. That'd be a detective control. But log files is an example of accountability. Before and after authentication, also used tied to identity. So if I've shared my username and password and my identity has been compromised, chances are the integrity of my log files have also been compromised, right? Shared accounts are bad. You knew that? Some people don't, but they're bad. Don't do shared accounts. Non-repudiation means that I can prove that you did what you did. You can't, there's no denying that you did what you did in the system, right? Non-repudiation requires the integrity of identity authentication, not as much authorization, but the identity and authentication have to be integrity. What's the word for integrity? Is that a word? Did I just make a word? Integritous. Yep, they have to be integritous for it to work, to get non-repudiation. I'm known for creating words because I can't think of a real word. All right. So other cornerstone security concepts, least privilege and least need to know. The main difference between these 2 concepts, they really are very, very similar. The main difference is least privilege is what I can do with the system. Need to know is what I can do with the information. So privilege is system, know is information. Does that make sense? So least privilege tied to access rights, basically what can I do with the system? Need to know is tied to the information. What can I do with the information? And definitely a violation of least privilege. So if I have excessive, so here's an example, administrator rights. If I've got administrative rights on my workstation or administrative rights on a server, I can easily give myself privileges or give myself rights to files and violate that need to know privilege or that need to know principle, right? So least privilege can lead to a violation of need to know, not the other way around, unless the need to know is a password database. That would give me another account, but that's not what I'm talking about. At 30%, admit to having no policy in place managing administrator access. You guys all have administrator privileged access policies and enforcing those things strong. Good. Of course we do. Another concept. Now, what we're doing here today is kind of laying, these are all memory kind of things, because this is all going to be foundational stuff that you're going to cover. We're going to cover again later on in more detail. We're going to take it and kind of apply it more. So subjects and objects, the difference between the two, a subject is an active entity. In the most basic sense, it's a user, right? Clicking around on things, and it's an active entity. It's manipulating systems and files and settings and those good things. An object is a passive entity. So in the classic sense, I have a text file and I have a user. The user is the subject. The text file is the object, right? And it all depends on context, right? Because there are times when an object can become a subject, right? Take a DLL file or a process. There's an object, there's a subject using that process, might be an application, but then let's say that process spawns another process, right? Now it's become a subject. So it's an object and a subject. Does that make sense? You gotta remember context, because you will get questions like that on the exam about subject object, and you'll just have to read the question and figure out what are you asking me and what's the context. Is this a subject or an object? Make sense? All right. Yeah, you will get tested on those. That's what that says on the bottom too. Yeah, Brad agrees. When did you take your CISSP?
September 15th.
Of last year?
15th.
Oh, 15. Oh, September 15th.
Yeah.
Not September 15th.
September 15th.
Okay. Yeah, so you've got, so that's good, because Brad might have more like relevant information about a current exam. Yeah, because it's been, like I said, it's been, 13, 14 years since I took it. So I don't know. But it doesn't seem like the content changed. It seems like I'm reading the same book that I read
I studied on the
50 years ago. You studied on the old book?
It's just where it lined up. The content didn't change.
So defense in depth. Do you remember one of the analogies I used last week? Last week, it was Tuesday. Remember back in 2012 when I was telling you about this defense in depth thing? Crunchy Shell GUI Center, right? That's how most people have set up their information security programs. They have a nice crunchy shell. No defense in depth, right? There's not network segmentation inside. They don't have, maybe DLP, some kind of data exfiltration type. I mean, there's just a lot of things that we can put in place to make it more of a defense in depth posture. Defense in depth it's compensating controls, right? One control fails. Let's say you get past my perimeter. What's next? And then you get past that. What's next, right? How deep do my defenses go in a defense in depth, right? And this is really common. Both of the breaches that I mentioned that I'd been involved in, responding to Target and Blue Cross Blue Shield, both severely lacked a defense in depth posture. Right? Once you got in, go where you want. Even in a cardholder data environment, if you guys know PCI, we'll talk about PCI later too, but a cardholder data environment is supposed to be an isolated environment. That's where the scope ends for PCI. You can still get into the cardholder data. 3389. Do you guys technical people? Who's technical? All right, so TCP port 3389, you know what that port that is? RDP. RDP was open from one network segment into another network segment, right? So what's the sense in segmenting? You know what I mean? Yeah, we're limiting our broadcast domain. Great. but there's nothing to stop an attacker from going from one to the other. That would be a defense in depth if I had additional layers of security inside. So multiple control safeguards to protect or reduce risk. Bypassing one control leads to the occurrence of another. One of the controls we'll talk about later on is a compensating control. That would be a number of compensating controls, kind of what do they call it? Attack chain? That's what they call it. What do they call it?
Attack chain.
Who?
Attack chain.
What did you say?
Kill chain.
Kill chain, right. So in that chain of events, right, all it would have taken was one compensating control to have not been bypassed to make the attack not happen. There's also a lack of detective controls too, because as I'm going, whatever, I'm gonna go for a while. Due care, due diligence. Now these are really, really important. And the reason why these are so important is this is what your executive management is thinking. Due care and due diligence. What's gonna keep me out of the news? What's gonna keep me from getting sued? What's gonna keep my liability down? And legitimately, that's what they're supposed to be thinking, right? You want them to maximize their business to make money, right? We're in business to make money. And so I'm focused on that, right? I'm not saying me. I'm saying an executive at a company is typically focused on that. So due care and due diligence. And it's important, that first one's important, not to provide legal guidance because we're not lawyers. I'm not a lawyer. I got challenged on that from a lawyer. Like, well, I noticed you wrote something about I think I was writing about due care and due diligence, and it was not long after the Target breach. And when I was asked to come and interview to be on the special litigation committee for Target, they one of the lawyers, and these are powerful lawyers. I mean, it was intimidating. He asked me, so, tell me about due care, due diligence. I was like, well, all right, and he's like, are you a lawyer? I'm like, no. He goes, why do you come off like one? I'm like, duh. So I just make it clear all the time. I'm not a lawyer, but I do understand what due care and due diligence are. Due care is, the prudent man rule applies. What would a prudent man do given in the same situation, given the same information? That's the due care. So if I'm operating in due care, I would consider facts and events and things and make good logical decisions on what I'm going to do about it. Due diligence is the actual application of due care. The key word in due diligence is formal, right? It's formal application of due care. So due care in the absence of due diligence still leads to, I think in most cases, depending on who your lawyers are, liability. In some cases, negligence, right? So, those are important. But the important thing to remember about due care is prudent man rule. You're a prudent man, we're talking due care. What would a prudent man do? Diligence is the management of due care. Negligence and gross negligence. Gross, I think, is just worse or uglier. I don't know. Gross. That was a joke. That was security humor. When I say gross, it's like, ew, right? Not that kind of gross. The other kind of gross, like big negligence. So negligence and gross negligence and not practicing due care. And you can be called out as reckless. We'll talk about what the consequences typically are for management who is negligent. Compliance. We're going to talk a lot about compliance later on too. We're just going to give a little introduction to some compliance things today. Compliance is critical. We don't have an option. I've been asked, I was in a security committee meeting with the CFO. The CEO was there, a large healthcare company, and the CFO had asked me, as we're talking about stuff, and he says, is there any return on investment in meaningful use? And I looked at him and I said, it's the law. You don't have a choice. I mean, whatever. So you don't have a choice with the law. And you'll also find out that this is a type of law. This is administrative law. You have no recourse either, right? You almost have no rights. And we'll talk. So compliance, just don't monkey with compliance. The trick is to build compliance into the security program as opposed to compliance being the security program. Those are entirely different. So compliance is essentially doing what you've been told to do, right? It's we've got laws. The laws say to do this, you do this. Where there's gray area, it comes down to the letter of the law versus the interpretation of the law. that's where that's the frustration you guys feel all the time when you're trying to figure out, what do I need to do for HIPAA compliance? What do I need to do for GLBA? What do I need to do for all these compliance issues? The frustration, I think, comes from the letter of the law says this, the intent of the law is this, and the interpretation of the law might be in something entirely different. So that's your frustration with compliance. You don't have a choice. Administrative, physical, technical controls. Again, the good thing about most of the compliance that I've seen, whether it be banking compliance, whether it be FINRA compliance, when you're talking about securities, whether it be HIPAA compliance, is they're all using a really pretty good definition of what security is. They're all talking about administrative, physical, and technical controls. They're primarily focused on confidentiality, but integrity is also very important. Availability, yeah, I don't know if they care other than DR stuff. So anyway, my preaching on that. Questions on compliance? We're going to all become compliance experts. You're a high trust person. You already know high trust really well. That's sort of compliance. So major legal systems. 4 major legal systems that you'll need to be aware of. One is civil law, common law, religious law, and customary law. It depends on the type of what part of the world you're operating in. So if you're working in an international company, different laws will apply to different places, and it doesn't really come down to your interpretation so much. It's the jurisdiction of the places that you're operating in that really matter. And for us here, in Minnesota, we only worry about common law, right? Religious law, we're not, Sharia law is probably the one that's in the news the most often. And customary law is just kind of customs. Normally it's like villages and things like that. It's also comes down to like the herd mentality between best practices comes into customary law.
I will say that they did test on that.
They tested on this?
Surprisingly more.
So you're all going to
You're gonna need to know the difference.
Go get your law degrees and pass the bar.
Well, I didn't say that.
No, not that much.
Not that much.
Okay,
just
good.
know the difference, because they will ask.
Yeah, they will ask this. This is a big driver for security right now, right?
So with adaptation of cloud security and so forth, is it where your data is held? Is that the law that then rules?
Yeah. So the question is, in a cloud application, what laws apply? Is it where the data is stored or where access is from? I think it depends. I don't know for sure. I would ask a lawyer. It won't be on the test, so you don't have to worry about that. But in real world stuff, I would defer to a lawyer.
Are you talking about like for breach laws?
Yeah, it could potentially be all. Right, but it also depends on how the law has been written in the place where they're accessing the data.
Just look at what happened to Lavabit to get a real world example of what will happen, because that
right. Yeah. So he said Lavabit. Take a look at Lavabit as an example of what did happen. Yeah. Good point. So anyway, these are the laws. So the first one is civil law. I crossed out the very. It is the most common legal system in the world. It's codified laws. It looks a lot like the U.S. way we do laws here. You have a legislative branch that creates the laws, and you have a judicial branch that interprets the laws. The number one major difference between civil law as a system, there's also civil law within common law. The major thing about civil law is that usually there's no preference at all placed on precedent, legal precedent. A lot of times a law will be passed in the United States and nobody really knows how to interpret it until there's a precedent that's been set. Precedent is very, very important in the United States. That's why normally I don't care too much when a law is passed, especially if it's kind of open-ended, because I don't even know what they're going to do with it yet. HIPAA was like that, but it was administrative. But still, we were waiting for some kind of precedent, with HIPAA. That's passed in 1996, right? Only really actively started to be enforced about 3 years ago. So just judicial body or branch interprets the law, no weight to precedent. So that's the major difference between civil law. If you look at the law in the United States and Just take out legal precedent. You'll know enough to pass the exam. Common law is the legal system in the US, Canada, UK. Codified law, so we have a legislative branch that creates the law, signs it, or creates the bill and signs it into law. And then the judicial body, or the judicial branch, which would be the courts, interpret the law. A lot of weight is given to judicial precedent. Precedent will often, I mean, you've heard what do you call it? Legislative for the bench, right? That's where they've taken the interpretation, and sometimes it seems a little wild, right? It's no longer fitting the intent of the law. That would be legislating from the branch or from the bench. Cool. Questions? All right. Religious law, religious doctrine, or interpretation is the source of the laws and statutes. We have tastes of religious law in the United States, right? We have it's a Christian basis. It's still there, but that's not a religious legal system. It's a common law legal system. Religious doctrine and interpretation is the source. Extent and degree of interpretation depends, and it varies from jurisdiction to jurisdiction. It can vary from sect to sect within a religion, right? Sharia law is interpreted in numerous different ways, depending on where you're at. Islam is the most common source for religious legal systems. Sharia law, Quran, and Hadith, I believe, are used for that. And you don't need to know too much more about religious law. And customary law, customs and practices within a jurisdiction, best practices that are used here. In some places you go, and you can have customary law within a larger legal system. Like they do things different down south, if you've ever been down south before, than they do here in the US, or US, than they do here in Minnesota, right? Go down and ask for a pop down there. But that's a funny example, but things are different. They have customs down there that are different than they are here, and vice versa. So best practices leads to negligence in customary law. So I just whipped up this quick graphic. There are the four legal systems. The one that we're really going to focus on is common law, because sometimes it's easy to get confused because there's two civil laws here. You have the civil law legal system, and then you have civil law, which is part of the common law system. Because there's civil, criminal, and administrative law in the common law system, which is what we deal with here in the United States. So criminal law, the victim is not any one person. The victim is viewed as the society. Criminal law is, to keep everybody in line, right? There's, what do they call it? What's the word? Deterrent, right? There's a deterrent effect too with common law, and there's punishment, right? You cross the line, you get punished. The important thing to remember about common law is proof beyond a reasonable doubt. Right? This becomes a really big deal when you talk about computer crimes, because in computer crimes, a typical sequence is a parole-based system looking for a weakness. I find the weakness, I compromise the weakness, I then elevate privileges, I plant a back door so I can come back later. And I come back in, and at this point I've either deleted log files before I planted the back door, or I'm deleting log files soon thereafter. But anyway, what I'm doing is I'm removing evidence. And the reason why that's a big deal is I need to prove beyond a reasonable doubt that you did what you did with the system in order to prosecute you under criminal law, right? So if you've destroyed evidence, another way is, proxying through anonymous proxies in other countries that don't cooperate with the United States. If I go through proxies in China, Iran, North Korea, I could be sitting in Minneapolis, I could be sitting in Laconia at my house, proxy through a bunch of systems, or I go through the Tor network, or I can do something like that. The reason why those things work is because I've removed that. I've inserted some doubt, right? I've got a good legal defense. Make sense? So it's a challenge when you talk about criminal law. Deterring crime and punishing offenders is the purpose for criminal law. Handcuffs. That's what happens. Handcuffs. Go to jail. It's bad. Civil law. So civil law is different. That's where you see most of the computer-related stuff and security-related things happening in civil law. The victim is an individual, group, or organization. Most commonly, it's one person suing another. I don't even have to have a case to sue you. I mean, there are frivolous lawsuits that happen, all the time. We're in a it's very litigious here, you know, in the United States. If you breach, there's a whole line of lawyers that are waiting to start that class action lawsuit. And, you know, I don't know, target breach, I think at one time there were 43, or there's probably more, but it just seems like I read that somewhere, that there were 43 civil lawsuits all happening at the same time with that target breach. You had the shareholders filing suit against the board of directors. I mentioned that one. That's called a derivative lawsuit. You had individual shareholders filing suit. You had banks filing suit. You had, I mean, everybody was suing everybody. But the victim is an individual group, most commonly between two parties. And you can't have one act prosecuted under criminal and civil procedures. It's really pretty rare. We don't hold, there's no law, we don't hold executives criminally responsible for the protection of assets. We hold them civilly responsible, so they don't go to jail. They do lose jobs, they do, you know. And I don't know if I've ever seen, I can't recall ever seeing an executive themselves being named in a lawsuit. I'm sure there's layers of protection from them to have that happen. So anyway, damages, often financial. There's a misnomer sometimes I've heard, you know, well, if I can't demonstrate that I lost something or that I was hurt by this action, then I have no case. Well, that's not true. That would only be in compensatory damages if that's the type of damages that I was seeking in my civil suit. There are two other types of damages. There's statutory damages, where you broke the law. The law says that you owe me this because you didn't do this or whatever. That's a statutory. It's codified. It's in the law. No loss or injury required. Compensatory damages are, you're going to compensate me for what I lost. It cost me, you know, $100,000 for me to get my identity back. So you owe me $100,000. That'd be compensatory. Punitive damages are, you did something probably pretty bad, right? You ticked us off now, and so we're going to punish you for it. In courts, sometimes they do that. Like that tobacco one is a great example of a huge punitive damage, billions of dollars. So the burden of proof, the difference here between criminal law and civil law is preponderance of evidence. Tilt the scale one way or the other. That's who wins, right? Whereas criminal law is, you know, again, proof beyond a reasonable doubt. Everybody has to agree that you did bad. So that's why the scale is in this picture, right? See how I'm using like images to just ingrain it in your brains. Never forget this. Look at it. I mean, look at it.
No matter how much you want to, you'll never forget.
You'll never look at it. Make it you. No, sorry. That's social engineering again. I'm not very good at it. So with the common law, also, okay, so administrative law. Administrative law is funky, man, because you guys deal with that when you deal with compliance. The law has been enacted by a governmental agency. It might have been at the direction of the president. It might have been at the direction of the legislative branch. Who knows? It kind of depends. So the agency interprets the law and enforces it. So you've got the government enforcing the law that was passed by the government, right? There's no separate branch that interprets this law. The challenge here is, let's say that I have a HIPAA violation, OCR finds me whatever, and I decide I want to appeal. Who do I appeal to? I'm appealing to the government. The government runs the court. The government's the one that sued me. Where do I have any impartialness in this? So you don't really push back with administrative law, right? If in administrative law, if you're found to be whatever, cooperate as much as you can and try to limit the amount of damage, right? It's very difficult to fight back against. And there's been cases, I can't remember, there was one when I was at that that executive summit that I was mentioning in last class. There was a guy that got out there and talked about how he lost his company. And it was a good, I can't remember the name of that company, because he fought back against, in this case, it was the FTC. He fought back against the Federal Trade Commission about something that they had found in a breach and whatever, but I'll have to find that information. But it was very enlightening that you don't fight it, really. He did, and he lost everything. So the agency enforces the government-mandated compliance, FCC regulations, it's Federal Communications Commission, HIPAA, FDA, FTC, you know, all that stuff. They're all GLBA, HIPAA, that's all. it's codified, but it's administrative law because it's actually interpreted by the governmental agency. So that's why I put the government there. They always have really nice buildings. All right, so liability, where's liability? So I don't want to be liable. I don't want to be the one to blame if something bad happens. We're not going to talk about reputation. So if something bad happens, and even if I'm not to blame, I could still suffer some pretty big damages. So who should be held accountable? Who should we blame? Who should pay? We apply the prudent man rule, so due care and due diligence. If I can't demonstrate due care, so what you'll see in a breach is immediately there's this shift from what do I have to defend myself? What do I have that can make myself the most defensible in this situation? So that's when the lawyers come in and let's do an assessment quick. Let's hurry up and fix a bunch of things because I need to defend myself. And where I'm trying to defend myself is I'm trying to demonstrate that I did do what I was supposed to do. I was running a good security program. I did what everybody else is doing, all that stuff. Because where that doesn't exist is, liability. That's just words matter to me. So I use definition. Even though I make up words, you guys know what I'm saying when I make them up, right? Like, what was the last one I just made up? Integridius. Yeah, you guys know what that means. So liability. That's your definition of liability, if you're interested. All right, so other things about investigations. This is important, I think, in incident response a lot. We have to protect the evidence. What types of evidence should we be looking for? If we're going to need to present in court, what evidence can we present in court? What evidence can we not? Again, you'll take it. The lawyers know all this stuff. You'll take direction from the lawyers if you're ever in this situation. They know all of this. So the types of evidence, real evidence, and this all comes from the rules, federal rules of, which might be in my next slide, federal rules of evidence. Federal rules of, that makes sense. Federal rules of evidence. These can all be found there if you want more, but these are the things you need to remember for the exam. Real evidence is tangible or physical evidence. When you anybody watch 48 Hours? My wife is like a 48 Hours freak, So when she's watching, it gets so tiring because that's another story. But 48 Hours, so physical evidence, right? They come into the crime scene, there's blood, there's a gun, there's a body on the floor. That's all physical evidence. That's all real evidence. Now, we don't have a lot of that when we talk about computers, right? Most of our evidence is electronic. So our computers, the evidence that we use in most computer cases, it's not real evidence. It's actually hearsay evidence, but there's some exceptions. We'll talk about that in a little bit. So direct evidence is firsthand witness information. Evidence. So, Matt saw me shoot somebody, and his testimony would be direct evidence. Now, you wouldn't have just had to see me either. You may have heard me. You may have smelt me. But it's one of your five senses, right? It doesn't have to be just sight. So that's direct evidence. Circumstantial evidence it establishes the circumstances that surround the facts of the case. They don't support the facts. They're not directly related to the facts themselves. They provide kind of the periphery around the case. That's circumstantial evidence. Corroborative evidence is evidence that strengthens other evidence. And hearsay evidence is secondhand evidence. Usually that's inadmissible in court. So I heard Matt say that he saw me shoot somebody. That's hearsay evidence. It's not admissible. We'd have to go talk to Matt and say, Matt, did you see it? That's the difference. So hearsay evidence is normally not admissible. There are some exceptions. So 803. 802 is the rule that says, about hearsay evidence. Rule 803 and 804 give us the exceptions. I think it's important to remember 803 and 804. I don't think it's important to remember to read them. To know that computer log files are hearsay evidence. They're not direct evidence. They're not tangible things. They're known as secondhand. They're a result from something else, right? Something happened, and this is a recording of that thing that happened. It'd be the same way as somebody telling me that Matt saw this, right? applied to a computer. You see what I'm saying? So it's truly hearsay evidence, but these are the exceptions. Computer-generated logs are generally considered hearsay evidence. 803 records records and reports. So this is the law. This comes out of the Federal Rules of Evidence. The important things to remember are the things that I highlighted here in practicality. In the course of regular conducted business activity. So if I collected this evidence doing something that I wouldn't normally be doing, that would make it inadmissible, right? So this sometimes can come into play. It can give people a legal defense, like if, I'm gonna pick on you, Matt, just because I like you a lot. And you just take it well. Let's say Matt is, I suspect that Matt is doing things on his work computer they shouldn't be doing, right? Maybe he's stealing information. Well, I know you are not. But let's say I suspect that. And so I go to HR, or HR, I go to HR and HR says, well, let's increase logging on Matt's system. And it's not something that we normally do, right? So we don't have any policy that says we do this, no procedure that says we do this, So we turn on maybe web monitoring to catch Matt in the act, and then we decide, to let you go. But then we're going to take it a step further. We're going to actually prosecute you, right? We're going to go criminal on this. There might be a gap there because that may not be during the normal conduct of business. What I used to collect that evidence may not have been, may not be admissible. Does that make sense?
So you would have to use it on everybody.
On everybody, or I have a procedure or a policy or procedure that says that if somebody suspects something bad happens, this is the procedure that we follow. That would be normal conduct of business, right? It's a small loophole, but I've seen it before.
That's what you're doing. This slide and the previous one, they definitely test. So everything that what the types of evidence and highlighted, and then on the hearsay, I have multiple questions about what kind of evidence would this be in this exam.
Okay.
So make sure you know that stuff.
Yep, and for the people online, Brad, who took the test in 2015 and killed it, probably got 100%.
Sure.
You're a Caps fan. Yeah.
They don't tell you, so yes.
Right, they don't tell you, exactly, right. But he said that this slide and the next slide are really important for the exam. You saw multiple questions on it. Good stuff, thanks. So in the course of normal business, regular practice of the business activity, we just gather this information. This is how we normally would do it. And Rule 1001 allows you to use a copy, because the standard best practice is I'm not going to do forensics on the original disk, right? Because if I compromise the integrity of that original disk during my investigation, what do I have left to investigate, right? And so because it's kind of a one and done thing. So normally what we do is we create a binary copy. A binary copy means that it's a block by block copy of the drive. It's not an image, right? It's a block by block copy of the hard drive. It's an exact replica of the hard drive. I can conduct my investigation on that, and that would be admissible, as long as I could, maintain the chain of custody, maintain I can make the case that it's still integritous. All right, other legal aspects. So the best evidence rule. The best evidence is the court wants the best evidence possible. That seems to make sense. Should be relevant, authentic, accurate, complete, and convincing. Direct evidence is always best. So physical evidence is always going to be better than any other kind of evidence I have. Secondary evidence, common in cases involving computers. We would call computers, logs, things like that. So in a case of a computer crime, I still have some direct evidence. I have the computer itself. It just doesn't help me prove anything, usually. We used to, when I was at US Bank, and when I was working on their threat, we used to do a lot of investigations. And when we got called into an investigation, when we seized the computer, we would take a picture of it. That would be part of the evidence, because this is where we saw the computer when we walked in the room. This is, how it was positioned and all that other stuff. You never know. You never know if opposing counsel or, somebody's gonna, question that. So take a picture of it. It's easy to do. That would have been best evidence, right? The computer itself is actually the best evidence. The picture corroborates the best evidence. So secondary evidence is that evidence integrity, super duper important. That's one of the number one things that, let's say it's a civil case, because most of the time it'll be a civil case. If I were challenging, if I was defending somebody, I would challenge your evidence. How did you get that evidence? How did you maintain custody? What's the quality of that evidence? Is there any opportunity for somebody to compromise the integrity of that evidence? Your interpretation of the evidence. So the evidence integrity is really, really important in a case. Chain of custody forms are important. I think there was an example of one in the book. It can be really simple. Essentially, all I need to do is record the date, time, who had the evidence, and who is getting the evidence, and ideally a reason and signatures. Right? That's all you need for a chain of custody form. Questions on any of that stuff? You guys still hanging in there? It's exciting. Security's fun. I told you that. All right. So other things about investigations. Fourth Amendment of the U.S. is, the unreasonable search and seizure, or it only applies to law enforcement or those who are working under the color of law. So the color of law is law enforcement told me to do something, and I go and do that thing. I'm operating under the color of law. That's important in an investigation. If one of my first things in my incident response procedures is to call law enforcement, it's never my suggestion, is that hold off for a long time for law enforcement, actually, because one, you're relying on their expertise. And I don't know that varies so much from jurisdiction to jurisdiction. Where I live in Carver County, they have a cyber unit, but I don't think it's very good. So would I rather call a cyber expert, or would I rather call them? Right? There's nothing legally saying I have to report it to the police. So I don't usually, and another thing is then it becomes a criminal matter potentially. And if it becomes a criminal matter, that means they control the investigation now, right? Because I can't do anything anymore because I'm trampling on evidence potentially, and I could be held, destruction of evidence is a big deal. That's another reason. Another reason is I can't control the disclosure of this breach anymore. Who else is going to find out about it? It's probably going to hit the news pretty soon if it's a big enough deal. That's another reason. Another reason is color of law, right? If I am going to do something, now I have to keep in mind, the police told me to do something. Do they have a search warrant? Is this reasonable search and seizure? If it's not, then I'm in violation of the U.S. Constitution. Now I'm a criminal, potentially, right? I can get prosecuted for operating under the color of law without a search warrant. Does that make sense? So I don't call police normally. I report it maybe later on, but it's just not where I'm going with it. So in all cases, the court will determine if evidence was obtained illegally. It's their interpretation, whether or not. So law enforcement does need a search warrant issued by a judge in most cases. Now there's a whole bunch of loopholes in this nowadays with the Patriot Act. But these are generally what apply. So the evidence, I can search and seize it if it's in plain sight. So I'm a police officer, I walk up to a car and I see a gun sitting in the back seat. That's in plain sight. I can grab that gun. Same thing if you open the door for law enforcement and they see through the window a big pile of cocaine sitting on your I don't know, wherever people put piles of cocaine. But they see it through the door, right? Okay, that's plain sight. Public checkpoints has also been challenged and precedent has been set. Legal checkpoints are also a reasonable search and seizure. Exigent circumstances, so there's an immediate threat that somebody's going to lose their life or the evidence is going to be destroyed. I've seen that tried to be applied a little bit to computer crimes. I don't know what the outcomes of those things would be, but it's interesting. I don't know. For the test, all you need to know is exigent circumstances allow me to not worry about it. For instance, there's a virus or something, and this is a criminal matter, can I go and grab that computer thinking that maybe that's going to destroy evidence or something? Is that an exigent circumstance? I don't know. And color of law. Any questions on this? Color of law is important. I don't want anybody going to jail. Other issues with legal and regulatory entrapment and enticement, the big difference between these two is the intent. The intent of the person who is enticed or entrapped. If they already had a criminal intent, that's enticement, that's legal. If they did not have a criminal intent and they get entrapped, that's illegal, right? So, well, illegal meaning it's not going to stand up anywhere, you're not going to get anywhere. And I suppose they could turn back and do civil. These are both criminal things. So the difference between entrapment and enticement, right? Understood that? Okay, honeypots. Anybody know what a honeypot is? There's some legal there's been challenges and things around honeypots, whether that's enticement or entrapment. It's really hard, I think, to determine what somebody's intent was. When you're talking about, there's a system out there that's completely, vulnerable. And I was just scanning. Scanning actually is actually illegal. Vulnerability scanning on the internet is illegal, but nobody prosecutes because it happens all the dang time. But honeypots, is that enticement or entrapment? How do you tell the intent of an attacker coming across a honeypot? There's been challenges on that. So just be careful. My suggestion is on honeypots, if you're thinking about setting up a honeypot, just get legal representation. Make sure the lawyers kind of signs off on it. It's a good idea. It's easy to do too, unless they charge you $550 an hour. It's not easy to do. So intellectual property, trademarks and service marks. You don't need to register a trademark. That's the TM, the superscript TM, the superscript R. The difference between those two, they both protect the same thing. They both protect the trademark. The difference between the two is one's registered, one's not registered. The one with the R is registered. It's easy enough. Creation of a distinguishing brand applies to a name, logo, school, or image, not a work of, that's a copyright. That's a little bit different. Applies to name, whatever. It can be used freely by anyone, unregistered trademark, the TM. So you can put a TM on anything you want. Yeah, go ahead.
What level of protection does just picking a TM offer? It doesn't
I don't
sound
know.
like there's a legal protection there.
Yeah, I don't know. So the question is, what level of protection is offered by the unregistered trademark? I honestly don't know.
Just more or less a deterrent.
Maybe a deterrent. I suppose if somebody else is, if you have a business and you're using this trademark to build something and somebody else is a business and using the same thing, I suppose you could do a cease and desist or something. I mean, we've done cease and desist before on copyrights, but never on our trademarks. So I don't know. That's interesting. I'm sure a lawyer would be able to tell you. And then the superscript SM is a service mark. So that's not a name, logo, symbol, or image. It's a service provided by an organization. And then there's just some examples. So this is one of ours. So Security Studio, it's got the TM on it. That's a unregistered trademark. It's in, and I should tell you, the U.S. Patent and Trademark Office, is where you go and register one. And it's not all that expensive. I don't know what we're paying for that, but that will soon be in R. So FISA, that's our assessment that we do. That's also trademarked. Coke Zero I thought was interesting when I was just kind of doing some little bit of research. I would have thought Coke Zero would have been a registered trademark. Coca-Cola is registered, but Zero was not registered. There's the Coke Classic is registered. And there's a service mark. Create the Good, AARP. So Create the Good must be some kind of a service provided by AARP. So you can see how they're kind of applied. Patents provide a monopoly. So if I file a patent, it has to be novel and unique, and it also has to be useful. If I apply a patent and it gets approved, there's provisional patents. You don't have to get into any of that too much. But a patent gives me a monopoly. I can, in exchange for me making this publicly available, meaning I'm going to take this to market, I'm going to make sure everybody can use this thing that I've created. I have a monopoly on the thing that I've created for 20 years. Right? After 20 years, then anybody can make a duplicate of it. You see this a lot in pharmaceuticals. This is when generics come out. It's after the patent expires. So pharmaceuticals are priced so highly because they only have a 20-year window, and they probably registered that patent well before they went to the FDA for approval. And the FDA approval can take 5 years more. So you've already lost those 5 years, so they have to recoup the costs of everything. That's one of the reasons why it's so expensive. And then when generics come out, everybody can make it. But the generic drug makers, people that make the generic drugs didn't have to pay all the costs to develop the drug. Make sense? That's one application of it.
So does the patent expire back to the priority date of the original provisional application?
I don't know.
But yeah, probably.
I think the patent itself starts when it was approved. The provisional patent is good for 12 months, I believe, while it's in
And
the
then you
patent,
convert it to
an approved patent.
a standard application, and then you wait for them to make a decision. So while they're making the decision,
That's the provisional. It's not?
no,
Okay, well, I don't know.
you file a provisional so that you can secure your idea
Okay,
while you're still developing it,
okay,
and then you convert it to a full patent application.
okay.
I'm just curious, at what point does the ticker start at 20 years? Is it
I don't know.
like when you filed the provisional, or when they said, okay, sure, you can have that?
Yeah, I don't know. So the question was, when does the ticker start for the 20 years? When you file the patent application, the provisional, or when it's been approved, right? Yeah, I don't know. I was always under the assumption that the provisional patent was while they're approving it. Yeah, so I didn't even know that. I don't know when the 20 years starts. I don't think it's testable, but what is testable is the 20-year time frame. So after patent expiration, it can be produced by anybody and sold by anybody. So copyrights under copyright law, which is a whole nother, kind of part of law. Two limitations that you'll run into: one is fair sale, one is fair use. Fair sale means that I can sell it to somebody else. So I bought, a CD, bought my Metallica CD, right? And I sold it to somebody else. That's legal under the fair sale. I can also sell it for more, right? I can sell it on eBay if it's something that's really in high demand. That's also legal. Fair use means I can make duplication without the consent of the copyright holder. I believe that's just for your own personal use. You can't make copies and then distribute that to others, right? You get that FBI warning every time you put in a movie. But I can make a copy of it for my own use, right? I want to make a copy. Maybe I want to burn it to, or I want to put it into, my laptop. I can do that. So licenses, there's usually a copyright license, some type of a license agreement that I sign or agree to. A lot of times we just, if it's computer related, we just click through it. You probably didn't read it. I have heard of people redlining end user license agreements. Even one lawyer that I read about who tried to redline a Microsoft end user license agreement. Wonder how that went. But EULAs, yeah, we approve. People click that stuff all the time. I wonder how really, yeah, anyway, I'm not going to go there. So trade secrets are other things. Now you don't really file a trade secret with anybody. You don't put a mark on it. The thing with trade secrets is it's kind of a thing that makes you unique, right? It's the thing that gives you a market advantage. The secret sauce, right? So the recipe for Coca-Cola, or what are all those spices and the exact mixture that go into Kentucky Fried Chicken. That's the secret sauce. That's a trade secret. The thing with trade secrets is they have to be actively protected. Otherwise, they could be considered not trade secrets at all. So actively protected to be enforceable using due care and due diligence. So if this truly was a trade secret of mine, what would a reasonable person do to protect that information? If I made, $5 billion off this trade secret, you'd think I'd protect it pretty well. If I don't, or, falls below that and it gets compromised, then, it could suck. So intellectual property attacks. So all these things we've been talking about are all intellectual property related. These are constant problems. We were asked, who was here? Somebody at FRSecure was working with a customer of ours. Oh, it's a law firm. Can't remember the name. Not that I would say the name, but I can't remember who they were. But they were asking us, they have an office in Shanghai. Did you ever hear this? Did you ever hear this? They have an office in Shanghai, and they want to know how they can protect their intellectual property and their data in Shanghai. I'm like, well, I wouldn't even try. I mean, I don't know. I really don't. I don't have a clue because it's just so much. It's just so much different. I don't even. Yeah. So it is but it is a constant problem. Piracy, copyright infringement, Pirate Bay, BitTorrent. I mean, there's a lot of ways where people are. Copyright infringement would be copying, the fair use, a violation of the Fair Use Act. Where I copied it and I distribute it to everybody, make it freely available. That'd be copyright infringement and/or piracy. Cyber squatting. Cyber squatting is, I know that Matt has this great company idea, and it's gonna be huge. Well, I'm gonna register the domain before you do, and then squat on it, right? It isn't a big deal. Is it like it used to be? It was. And there were millions of dollars, billions of dollars created in the .com boom. People were cyber squatting on everything, right? And at the time, the laws really hadn't caught up, so people were paying it. That's cyber squatting. So the other one is typo squatting. So if you type in, one of the popular ones was www.utype.com, because you and I are right next to each other. Now, if you type that in, it resolves to youtube.com because Google took that and made it back to what's supposed to. But typo squatting is, a common website. Just do a couple letters off and, squat on that, and you might do whatever with that site. Counterfeiting, it's a big deal, right? Especially China. I'm going to show like an example where they replicate, they counterfeit entire Apple stores. It's not enough just to do the iPhone itself, but the entire store is counterfeit. And dilution. Dilution really isn't an attack. It's just something that happens with intellectual property. Like take Kleenex. Kleenex is a brand name. It's a registered trademark, but we all refer to things that we blow our nose with as Kleenex, or not all, but a lot of us. Bandages, Band-Aid is another example of dilution. It's just, it doesn't set them apart anymore. So there's it looks like an Apple store, doesn't it? It's just the boldness of it all. And then UType, just a couple of examples of the different, that's counterfeiting. This is typo squatting. So privacy, confidential, personally identifiable information, a subset of security. We've talked about that a little bit already. Examples of personally identifiable information. Now it depends on who you're talking to. That's been one of our challenges in dealing with personally identifiable information and protected health information. What is protected health information? And I've asked the OCR that same question. The OCR is Office for Civil Rights. They're the enforcement arm of the Department of Health and Human Services that deals with HIPAA. And you get different answers all the time for that. But examples would be PII, protected health information, bank account information, something that's personal to an individual, that's meant to be confidential, would be personally identifiable information. There are many privacy laws throughout the world, and there's changes happening every day in privacy laws throughout the world. We used to have the EU, US safe harbor, right? The EU has their own privacy law. Now that's kind of going away. We'll bring that up here in a minute too. So EU, but for the test, you don't need to know that it's been sort of supplanted with another law. What you need to know for the test is this, right? And this is good basic stuff anyway. So EU privacy, European Union, aggressive pro-privacy, notify individuals how their data is gathered, how it's used, allows for opt-out, sharing with third parties. Opt-in is required for sharing the most sensitive data. No transmission. So the big key here for us here in the US is no transmission outside of the EU unless the receiving country is perceived to have equal or better privacy protections. The US doesn't qualify for that. So that's where the safe harbor comes into play. Safe harbor was, yep. Oh. So the safe harbor, Department of Commerce, is a website. That's just a screenshot of that. April 12th, 2017, no longer accepting U.S. Swiss safe harbor. So the Switzerland is part of the EU, but this is a little bit different. So now it's the Privacy Shield. So if you do business in the EU, and the Privacy Shield framework is voluntary. I don't know how it applies. I don't have many of my own clients who are working in the EU. Do you have any?
No, I don't.
Okay.
Barely in Minnesota.
Barely Minnesota, all right. So I'm not sure how this is all going to play out, but I think one is going to be taking the place of the other. But for the test, if you know this, you're fine. EU, safe harbor, and how it applies, and Department of Commerce and all that good stuff. There's also OECD, so the Organization for Economic Cooperation and Development. And honestly, I'd never run into this, OECD. The only time I've ever run into it is in the book. Every year, once a year, I'm like, oh yeah, I remember that. Okay. So I don't know how much it really applies in the real world, to be honest with you, but 30 member nations from around the world, including the United States, they focus the organization itself, not the privacy law or rules or guidelines, focus on things that impact, commerce, across the global economy. So in 1980 is when they issued the Protection of Privacy and Transporter Flows of Personal Data. That's probably why I don't hear about it ever. So I'd say this is one of those things that know it for the test and then dump it. 8 principles, 8 driving principles, and they all sort of make common sense, right? The collection limitation principle. So I'm only going to collect the personally identifiable information or the privacy information that I need to conduct business. The data quality principle, it needs to be accurate. The purpose, I need to specify why I'm using that data. The use limitation, I'm going to restrict myself or be restricted to how I make that it fits with the others. I'm going to put safeguards to ensure that I'm doing it. Openness principle, individual participation, accountability principle. It's not mandatory, and I'm not sure how much it applies. I think for the exam, if you knew OECD and that there were privacy guidelines, that the US was part of it and that there are 8 principles, I think you'd probably be fine. I don't know if you need to know the 8 principles themselves. Did you ever have the 8 principles? Do you recall? Yeah. So I wouldn't spend a ton of time memorizing the 8 principles. Know that there are 8. And I guess, maybe spin through it a couple times just to, so when you see it on the exam, you're like, no, that one seems dumb. That one's definitely, because like I said, in the exam, typically there's 2 that you can eliminate. If it's the standard multiple choice, there's 2 that you can eliminate right away. Then you'll just have to, if it comes down to, if they do ask you detailed questions on this, maybe just guess on the other 2. You got a 50% chance at that point. If you don't answer at all, then it's the same as wrong. Other rules and laws. So this is where we're just going to introduce you, right? Just going to whet your appetite a little bit about these. You probably have dealt with these, or all of us have dealt with them. It's whether or not we're really dealing with them, or if we just sign a bunch of papers every time we go to the doctor and we don't know what they mean. But we're dealing with it. So HIPAA, the Health Insurance Portability and Accountability Act, passed in 1996. Immediately, the privacy. So there's really 3 main rules to it. There's privacy rule, security rule, and the data and the breach notification rule. The privacy rule took off, right? The breach notification rule didn't come until later, much later, 2009. But 3 rules. Privacy rule around privacy, data privacy. That's when you started to have to, I don't know if you remember back then, but before then, you just go to the doctor, it seemed like, I mean, you didn't have forms and stuff. But in that, soon after 1996, you had that. Security rule really wasn't actively enforced until meaningful use, I think, is kind of when I first started really seeing it. Meaningful use came around 2000, I don't know, what year is it now? 17? Probably 2013-ish, 12-ish, somewhere in there. Meaningful use became kind of a big deal because now I'm going to get reimbursed for going to electronic medical records, and one of those meaningful use requirements was number 15, I think, 13, 15, whatever. The last one was that I've done a security analysis, risk analysis, and that stuff. That's when it became a big deal. But applies to covered entities and now also business associates, thanks to the omnibus rule in 2013. the cool thing about the security rule that I like is it does mention administrative, physical, and technical safeguards. Safeguards is another word for control. Those are interchangeable. And risk analysis is required.
Question came up, do they need to know HIPAA itself for the test? No, you just need to know what's on this slide, what it's about, and the standards, but they're not going to ask you specifics of
No.
the security rule.
No. Yeah, you will not have
Do
to
they try
read.
to trick you
You will not have to read the law.
with the 2 Ps versus the 2 A's?
Did I do 2 Ps?
It would be more about,
No.
Oh,
No, you made the-
It's,
I got a story behind that. When we first started FRSecure, this was, well, actually, it was just me for a while, right? And then Kevin came on board, and we were like, oh, let's make these. I don't know if we still have it somewhere, but we made these banners. And the first one he made was HIPPA. And we used the same banners like 3 years, and nobody ever pointed it out. So I was like, there's no use in it. It doesn't matter what your banner says.
well, seriously.
But we didn't even notice that. It was like one of our, employee number like 13, 14, we're like, what the hell? I'm like, son of a, really? I've been using that for like 3 years. We should see if it's still around somewhere. Other rules and laws, so the Electronic Communications Privacy Act, this is about all you need to know about that. Protection of electronic communications against warrantless tamping. Really changed a lot with the Patriot Act. Now, the Patriot Act came about, kind of after 9/11, because everybody remembers 9/11 if you're around. That really weakened ECPA. So, Computer Fraud and Abuse Act. That is still the most common law used to produce, to prosecute computer crimes. It's been amended a number of times. It was enacted in 1986. You can see all the amendments. So it tracks along kind of with technology, right? 1986, the things that happen today, they never even conceived in 1986, and so on and, so forth. But that's probably plenty too for now. Patriot Act of 2001, passed almost, in lightning speed for the government after 9/11. Expands law enforcement electronic monitoring capabilities, allows search and seizure without immediate disclosure. So I don't have to get a warrant in some cases. If I meet these specific criteria, and you don't need to know what those criteria are, just know that it loosens ECPA quite a bit. GLBA applies to financial institutions. We got some bankers in here. They get to live with that. Driven by the FFIEC. So the FFIEC sort of is that governmental agency that interprets GLBA. Enforcement agencies, member agencies of the FFIEC. You've got OCC, Office of Comptroller and Currency, FDIC, Federal Deposit Insurance Corporation, FRB, Federal Reserve Board, blah, blah, blah. NCUA, credit unions. CFP is the Consumer Finance Protection Board. Do they do anything? I don't think they do anything. Nobody ever hears of them. I don't know. But those are the agencies of the FFIEC. It depends on your charter. You don't need to know any of that stuff. You just need to know GLBA, FFIEC, and if you see one of these other acronyms, that's somebody. Yeah, exactly. Enacted in 1999, and that's been through tons of changes too, right? Now they've given you the cybersecurity assessment tool. I think the based on CSF. CSF, I don't think is testable, so we don't have to go into too much about CSF. That's the cybersecurity framework. Is that testable? Maybe. We'll see.
I don't remember.
It's not testable yet. We're not going to cover it yet. But
Pretty fresh.
yeah, it is pretty fresh.
They usually run several years.
But that should be something that we'll have to make a note that we should talk about that at some point, because you should know what that framework is if you want to be a security person, even though it won't be on the test. Know it. NIST CSF. California Senate bill. This was a huge deal when it was originally passed. It was kind of the first ever breach notification rule, and they went kind of hard on people. And it's still, they're amending it and things, but it regulates the privacy of personal information. One of the first data breach notification laws. It was number one. Now we have 48. New Mexico just recently passed their breach notification law. So it was 47 for a very long time. Sarbanes-Oxley, SOX, related to the financial scandals of the 90s. I don't know if anybody was around in the 90s, but you know, that was a wild time. Enron, yeah, and then MCI, WorldCom.
So what the accounting scandals, the consulting CPA firms that were cooking books for people?
Oh yeah, everybody was in on it. Yeah, Anderson Consulting. I don't remember what their name was before they were Anderson Consulting, but they were Anderson something, and they were huge. Arthur Anderson, right? Yep. And then that all thing happened, and then yeah, got bad. Bunch of stadiums had to be renamed, right? Well, we don't run into, honestly, in our day-to-day work, we don't run into Sarbanes-Oxley very much. If we are, it's around the security of the financial reporting systems, right? And that's about it. They're very strict and rigorous on that now. I mean, meaning they've got things worked out, and the CPAs are handling all that now. We don't do much with SOX. Other rules, PCI. So PCI, this is not a regulation. PCI is a private industry set of rules, standards. PCI, PCI, I don't remember the first version, but anyway, PCI DSS is the data security standard maintained by the council. Originally, it was Visa, MasterCard, Discovery, and Diners Club or something, I think, that originally came up with the standard. It applies to cardholder data. And if you ever hear cardholder data environment, you're talking CDE, you're talking about PCI stuff. Not governmental and not a law yet. Now, the reason why it's yet is because, man, they've been trying to, every time there's a major credit card breach, they call the council to testify or call somebody, Visa, or multiple people to testify in front of Senate committees and whatever to inquire. And, thank God they haven't made it governmental. I don't know if you guys, my personal experience is anything the government does, they usually don't do right. So I get nervous about things like that. So it requires merchants and others to meet a minimum set of security standards. Now, liability used to lie with, no, still does. It lies with the kind of the issuing banks, I think more. I mean, they're the ones that seem to foot all the money, all the bills. But now, you've got EMV, and now it's really pushed liability to the merchants. So, but that's kind of half enforced too. So I don't know. But it mandates security policy, devices, control techniques. This is what you need to know for right now for PCI. If you need to know more, your husband's a QSA. Yeah, we're a QSA too, but we are QSA. He's a QSA in the QSA. So QSA is a qualified security assessor and whatever. It's a lot to PSI, pounds per square inch. There's a lot to that too. There's a lot to PCI. So breach notification laws. For the test, there's 47. There's actually 48 though in real life. New Mexico just passed, recently within the last month. There's no federal breach notification law, which becomes really kind of messed up, right? And some state attorney generals are more strict on enforcing their breach notification laws than others. So it's kind of a mess, really. But conflicts arise in interpretations, jurisdictions, definitions. Like, for instance, I have data that belongs to a resident of North Dakota, right? But now they've moved to Nevada. So do I have to notify the North Dakota and the Nevada, or just the Nevada? Do I need to notify it all because I'm in Minnesota? It depends on the law. Each law is written slightly different. So they can get kind of messy, I guess. Safe harbors may or may not be provided. Now, the reason why, you used to be pretty much just rest assured that if I encrypted the data at rest and the laptop was lost or stolen, I had a safe harbor. Most laws were written for that. Some of them weren't, but now they're changing things. Like Tennessee, I think, just backed off on that safe harbor. So lawyers, get the lawyers involved for sure. If you have a breach for a lot of this stuff, they may recommend. I've seen lawyers recommend, don't even worry about the state breach notification laws. I mean, I don't know. I guess it's what a lawyer would say, maybe. So that's breach notification laws. It's a mess. It's difficult. I don't spend a lot of time trying to understand if there's a breach. Okay, you need to notify this guy. What I typically tell the client is, do you operate in other states or have people that have moved to other states or anything like, oh yeah, sure. All right, there's a bunch of breach notification laws. Make sure that your lawyer is on it, I guess. But I'm not going to deal with it too much. 2 data protection laws. So the 2 data protection laws, these are prescriptive things, things that you have to have in place. And if you don't have them in place, then you are in violation of law. So this is regardless of a breach. Nevada and Massachusetts have these data protection laws. And then there's a ton of data destruction laws, right? So I can't remember the last count, but meaning that, if I no longer need data, I have to destroy it in this manner or what have you. Data openness laws, Freedom of Information Act considerations. I mean, it gets messy dealing with all this stuff. But for the test, breach notification laws, know that there are state breach notification laws and it becomes difficult. There's no federal law. There's been numerous attempts to pass those. I don't know why. I don't know why they haven't. Vendor risk management. Easy, right? Let's move on. So vendor risk management is a deal. Because if I'm the custodian of the information, and we'll get to that one too, when we talk about data classification, we'll talk about the data owner versus the data custodian versus the data user and, all that stuff. But if I'm the custodian, I'm responsible for protecting this information and I allow a vendor to come and service my servers, let's say, and their computer is infected because they had improper protections on that computer. And now it's been siphoning off all my sensitive client data. And now there's a breach, right? So anytime I engage a vendor and the vendor has any kind of physical or logical access, technical access to any of my systems, I need to do I need to account for that risk in my environment, right? And they don't treat your data as securely as you treat your data. I don't know if you've ever seen that before, but vendors don't really seem to care as much as I do. So attestation, I need to attest to the fact that the vendors are protecting my assets adequately. Now, either I do this myself, now it's become part of due care, due diligence, but now also the laws are going there or have been there. HIPAA requires, that you account for vendor risk management. GLBA, requires that you do vendor risk assessments. So risk assessments, so the attestation, so that's one way that I could assure that the vendor is doing what they should be doing to protect my information. I can do a risk assessment of the vendor or have them do a risk assessment and give me the evidence of the risk assessment. The one that we, do a lot here is FISA. That's our assessment. You see a lot of people asking for SOC 2s. There's a type 1 and a type 2. If you know how a SOC 2 works, easily gameable, not really a good attestation. It's just not. Like when I get to manipulate the illustrative control to state what I want it to state and then give you evidence that I'm meeting my illustrative control, and the auditor doesn't know the difference between an illustrative control, how to map the illustrative control to the risk, to the criteria in a SOC 2, it's very easy to game a SOC 2. It's also easy to game a SOC 2 with the system description, right? The system description, if I narrow the scope enough, it's a lot easier for me to apply those controls. So really pay attention to the system description and the illustrative controls in your SOC 2s if you're using them for this, right? A lot of people aren't. A lot of people, oh, you got a SOC 2, okay, great, thanks. And they file it away and it's done. Read the SOC 2. If you're using it for attestation, read it. Make sure the system description includes the systems that you are concerned with. And 2, that the controls match the risks. And you'll be good. ISO certification is another thing that, we've seen people ask for. High trust certification is another. Shared assessments. Shared assessments was, I don't know if you ever received the SIG questionnaire. Have you ever heard of that? The SIG questionnaire that comes from shared assessments. It was a consortium of banks that got together and said, how are we going to tackle this vendor risk management thing? They created this huge monstrous questionnaire, and then oh, it's way too big. Let's create a SIG light. It's still too big. So whatever. That's shared assessments. PCI DSS, ROC, report on compliance. It's another thing that you could ask for. I wouldn't ask for it unless the customer is processing credit card information. Otherwise, why the hell would I have a rock? Well, we've seen people ask that before too. We have a large printing company who's a customer of ours, that their customer said, do you have a PCI rock? And they're like, no, we don't have any credit card data. And they said, well, we might give you credit card data if you get a rock. Well, it's like the cart before the horse, right? So I'm supposed to create this cardholder data environment and then have a QSA come and issue me a rock on something that really isn't there. That's weird. So right to penetration. Okay, so that's one of the things that we like to see in contracts. When we're doing assessments, and we're doing assessments of vendor risk management, we want to know, you have the right to audit in your contracts with vendors. That means that when I want, whatever the contract says, but ideally, I can spot check things. I can, come on site and I can review something. I can give you notice that, hey, tomorrow I'm going to come out and just whatever, right? Audit what you want to audit. Make that part of your internal audit program. That's a good thing to have. And sometimes that'll even, if they're paying attention, I guess, it might scare them into compliance a little bit. Not scare, but you motivate them into compliance. Procurement. So procurement is, don't forget about how you get things, where you get things from. Those will be really important when you talk about, disaster recovery, business continuity. Acquisitions, if your vendor is acquired, what happens then? Or your vendor acquires somebody else. Those are all going to have changes to. You want to have a trigger of something to reassess. Divestitures also, selling things off. Personnel changes are important in vendor risk management. Significant management changes sometimes are important in vendor risk management. All those things. Any questions? So another thing here on vendor risk management, by the way, now with HIPAA, the omnibus rule, your business associates have the same requirements that you have as eligible professional if you are. Yeah.
Sorry, I didn't mean to.
No, good question.
Just vendor management, another good thing to do is check insurance.
Check insurance. Yep,
Sure
very good.
Insurance, professional, liability, in general, what the limits are, and you can be added as an additional insured as well.
Good. Yep. Good. So the recommendation for people online was, check insurance. Ensure that in financials. I mean, there's business risk stuff too. You can check financials, make sure they're going to stay in business and stuff like that. But yeah, insurance. We've seen some companies mandate other companies get breach insurance. That's still such an immature, industry. Yeah, I don't know if I'd go there, but we've seen companies do it. Might be legit.
I've seen it pay ransoms.
I've seen law enforcement pay ransoms. I know of two police office departments that have paid ransoms, which is ironic, right?
The insurance companies pay it for them though?
No, they paid it.
Okay. I was saying the cyber liability insurance I've seen pay.
Oh, pay ransoms?
For businesses.
Yeah, that's cool. Again.
And the forensics work after, just in December, I picked up a new client. They got ransomed. They were down for a month, and 3 IT companies, and one was a forensics firm, had been in there. They paid the ransom with Bitcoin. Of course, it was $7,500. The fee for the forensics firm to use their Bitcoin wallet and do the work was $7,500 also. But the cyber liability insurance.
So cyber liability insurance paid for the ransom and the forensics work around it.
Yes, and even me probably what it took for me to get them back on, and all the other IT people. I know they haven't gotten paid yet, but they're supposed to get it.
Okay, interesting.
Does that omnibus rule include all of their businesses they're working with, or specific?
So the omnibus rule only applies to HIPAA.
But it's all of their business?
So if you're a business associate of mine, then as a business associate, you need to be HIPAA compliant. Yeah, all of your business.
That's what it is.
Yeah. I suppose you could try to limit, if you segmented it off, or if it's a separate entity, maybe. But
well, we have different rules in maintaining by the criticality of each vendor rating that we get.
Right.
So I just didn't know if that law incorporated all of them, or the HIPAA, and it does.
All business associates. Yeah.
But if you get a business associate letter from a healthcare, you're gonna have
And
to follow
and you
that.
and a lot of eligible professionals and eligible hospitals and providers don't even know who all their business associates are. So you may not even have a business associate agreement and still be a business associate. I mean, we deal with hospitals all the time. Like, well, they have an account, but they don't ever access PHI. Are they a business associate? And I'm like, well, do they have the ability to access PHI? Yes. Well, then, my interpretation is they're a business associate, but check with your lawyer. At the end of the day, they're the ones that are going to have to defend that decision. But I think, err on the side of caution when you're dealing with the government, knowing that I have no pushback. So ethics, ISC squared code of ethics, very testable. You will see this on the exam. You'll see scenarios where I would assume, because I can remember back when I took it, that you gave me two things that were ethics file. I had to put one ethic in front of another, right? So I had to violate one to preserve the other, like lie to save somebody's life, something like that, right? So, and there were cases where I would read that scenario because I remember, because ethics violations stand out to me. They piss me off, right? I mean, I'm supposed to be a really ethical guy. And so, but I remember one, it was like, I wouldn't choose either one of those. I'd do this one. You'll see stuff like that. But so understand what the ethics are. These are the ones that you really need to understand. They call them canons. There's 4 canons, and they're in order. They're mandatory. The canons are: protect society, the Commonwealth, and the infrastructure. 2, act honorably, honestly, justly, responsibly, and legally. Provide diligent and competent service to principals. There's a lot of violators of that. Advance and protect the profession. There's a lot of violators of that too. 3 and 4. But anyway, those are your canons. They go in order. If there are conflicts, go with the higher one. So protect society, Commonwealth, and the infrastructure. That's paramount. Even if I'm incompetent in doing so, I guess. Does that make sense? Okay. Another one is the Computer Ethics Institute. There are 10 commandments. I think what you need to know for the exam is that there are 10 commandments that come from the Computer Ethics Institute. You don't need to necessarily memorize each one of the commandments. They all make pretty much, they're all pretty much common sense, I think, even though one of my principles is that there is no common sense in security. Thou shalt not use a computer to harm other people. Okay, sounds legit. Thou shalt not interfere with other people's computer work. I wonder if that means, like, when you come into my office and I'm in the middle of doing something, you're like, hey, Evan. I'm like,
I'm in trouble.
No. You're good.
No.
I'm not going to say who. Thou shalt not interfere with other people's computer work. I'm going to turn around and say that. That's a violation of ethics right there. Sort yourself out. Thou shalt not snoop around in other people's computer files. Thou shalt not use a computer to steal, bear false witness, copy or use proprietary software for which you've not paid. Yeah. So those are the ethics. 10 commandments. 10 commandments, Computer Ethics Institute. You're good.
What was it? I want to say, I remember there was a question about it, but it was, if you have read through this once, it was like, which of these is not? And it was
Okay.
really clear. I mean,
But I wonder if maybe knowing that every one of them is thou shalt.
yeah.
Because you won't see thou shalt
Basically,
anywhere else other than
it's common
Computer
sense,
Ethics
right?
Institute. Right.
So if you just have read through it a couple times, it was, I don't remember the question, but I remember it was very.
You can just tell who this was written by, can't you? When you read this, this was a guy with a beard much longer than mine, right? And this was written in, like, I'm guessing like mid 80s, maybe. They're just like total Unix, hardcore. You know what I mean? They're like, well, I know, thou shalt not. You're like, oh yeah, that sounds awesome. Fellow humans, like we're aliens or something. I don't know. That's just what I think when I see these. Nobody writes like this anymore, I don't think. Well, maybe there are some people. IAB. So the IAB also has their set of ethics. the ethics in the internet, defined as an RFC. So we'll talk more about RFCs later on. RFCs are governing documents for the internet, right? They stand for requests for comment. There are, I don't know how many there are now, but they're all publicly available. They're all written in plain text. This one was written in 1987. So considered unethical behavior, seeks to gain unauthorized access to resources of the internet, disrupts the intended use of the internet, wastes resources, destroys the integrity of computer-based information, and compromises the privacy of users. Pretty simple. This,
And on this, know those.
I would
Say
know.
which of these is not part of that.
Yeah, I would know these because anything you're going to see with an RFC is a governing kind of thing. It holds more weight than this. All right, security governance. I got 14 minutes. How many slides have I got left? What number is this? 10 slides. We're so on top of this right now. All right, so information security governance. The things to remember for information security governance are the differences between policies, guidelines, standards, and procedures, right? There are 4 distinct types of documents. Policy is mandatory. Most policies have a purpose statement, a scope. Who does it apply to? We usually organize our policies something like this, right? We have an enterprise information security policy, which applies to everybody. It's the charter policy, right? It governs the whole program. Very high level, roles and responsibilities, maybe some definitions. That's what goes in that kind of policy. These other policies are topic and issue specific policies. One of the problems we see in the practicality of policies is people expect others to read your policies. Nobody reads your policies, ever. They're not going to. Don't expect it. Don't demand it. Policies are reference documents. They're not books. So if I break them out by topic or issue and I organize them well, people will reference them, and that's what they're meant to be for. So that's why scope is important. Like if you take mobile computing policy, that doesn't apply to asset management. The asset management policy applies to asset management. You see what I'm saying? So scope is important. And once I break it out this way too, if I'm not a mobile computing user, I don't even need to know that that policy exists, right? So I only have to focus on the policies that apply to me, responsibilities and compliance. Now, again, words matter, right? So if I put something in policy, it matters, right? But I also, when we write policies, we also know that there are extenuating circumstances. There are things that happen that aren't usual, that I can't comply with policy for one reason or another. That's why we create a waiver process, right? So usually in the bottom of the enterprise information security policy is a waiver, that basically says, follow this process to obtain a waiver for whatever it is you did. You can do it retroactively too. The reason why we want that from a governance perspective is if you're not complying with policy, we need to know about it. Do we need to change the policy? If we get enough waivers for a specific policy statement, that tells me, as somebody who's governing the program, I need to change that policy statement, or we need to change the process. So we encourage people to use waivers. It also allows us to account for the risk in what you're planning on doing. We may have an alternative way for you to do something too. So waivers are really important, and that's, but you need to get into the practice of using them. That's bonus material, I guess. Policy types: program policy, issue-specific policies, and system-specific policies. All those types of policies do exist. One applies to the program itself, the high-level information security program. Others are issue or topic-specific, and some are system-specific and may have a specific application or specific server that is important enough, managed differently enough that it requires its own policy. Standards, guidelines, and procedures support policy. Policies are high level. I don't want to change them often. And if I do change them, I want to change them like add a statement, remove a statement, do, high level type stuff. So policies by themselves don't actually put the rubber on the road. What puts the rubber on the road is the standards, guidelines, and procedures. Now the difference between those is standards. Well, I guess we start with procedures here. Procedures are mandatory step-by-step guidance. Right? Take somebody, when you think through a procedure, whether this is a good procedure or not, take somebody who has zero experience. If they can read that procedure and accomplish the task set out in the procedure, that's a good procedure, right? I mean, that's the best kind of procedure because there's no gray area, right? It's very black and white. Follow these steps. Those are mandatory standards. They're also mandatory. Usually they're a little bit higher level than, or they are higher level than procedures. They provide boundaries maybe around a specific technology or the use of a specific technology, something like that. So like configuration standards for servers. I might have a set of standards that I use to configure my servers. And if you're going to put a server in my environment, it has to meet these standards. And the standards might say it's got to have these settings set to enabled and these settings set to disabled. Whatever the standard happens to say, that's a standard. It's not step-by-step on how to do it, but it's boundaries, right? That's a standard. Guidelines are discretionary. Guidelines are, this is how you could comply with a policy if you wanted to, not if you wanted to. Well, that's how it actually works, but it's not how it's supposed to work. This is how you could comply with the policy. Is a guideline. Advice, advisory, baselines or benchmarks are also mentioned in the book and are important to know. Baselines are usually related to a specific configuration or the activities around a system, but it's benchmarked. Right? If I see deviations from the benchmark, then it needs to be a reason for it. Like if I have computer configuration standards, which then becomes a baseline configuration, right? It's a baseline. How that system operates is now a kind of a baseline. If there's a deviation from that baseline, there's got to be a reason for it. And where I like that, if I'm really governing the program well, is that reason should be documented, right? If I have a change control process, and so when I go through and audit the system, and I see that settings have changed, I should have a change control, right? Or some reason it should be issued a ticket, something. If not, that might be an indication that I have a compromise, at least a violation of policy. I mean, there's got to be something here. Not that I'm looking for something. I find plenty of somethings, but that's the baseline. Any questions on that stuff? Okay. Personnel security considerations. So people are always the biggest risk. So, spend a lot of time with people, try to build a security culture. Security awareness and training, that's always a big hot topic with organizations. Those are two different things. Awareness is making it top of mind on a regular basis. That's awareness. Training is teaching you to do a specific task or skill. Get creative with training, make it fun, make it participatory. That's a real word, right? Participatory. Make it that way. Background checks are another thing. Criminal background checks, depending, some people will associate that with the level of access they have to sensitive information or financial information. If you have more access, the background check might be more in-depth or rigorous. Even FBI background checks, things like that. Types of background checks, criminal history, driving records, credit checks, employment verification, references, personal claims, professional claims, all those things, certifications. The more sensitive the role, the more checks. One-time checks and ongoing, right? People change over time. Employee termination, having a formalized disciplinary process, progressive. We'll get deeper into this later on. And then there's a time frame, right? I mean, usually you fit them into one or two buckets for terminations. It's either voluntary or involuntary. Involuntary terminations, access, to cut off within an hour. Maybe that's your SLA or your standard or your, I suppose you can put in policy, but probably not. And then voluntary ones, maybe, the day of, they're treated differently. Involuntary terminations, typically you escort them out the door. You ship them their boxes, potentially. Whereas voluntary terminations, hey, you have a goodbye party and do all this other good stuff. And, so different types of processes. Exit interviews, rights revocation, account reviews. So how do we know if we caught everybody on the termination process? Usually it's a user account review. The higher the turnover, the more often the reviews, right? Active Directory, that might be your kind of point of truth for user accounts. If you hardly have any turnover, sometimes you can get away with an annual user account review process. But if you have a high rate of turnover, maybe it's weekly. Dealing with vendors, contractors, third parties, they also have They have training needs, believe it or not, so incorporating them in your training and awareness program, making sure that they're complying with your policies, making sure that they're aware of your procedures, dealing with vendors, that's almost always an oversight. People just don't think to train them the same way, validating that they are doing background checks. If you have right to audit, I want to see a background check on Joe who keeps coming here once a week. I have the right to audit, so I'd like to see that. Oh, geez, we don't have that. Well, that's a big deal sometimes. So, stuff like that. Outsourcing, offshoring, whole nother can of worms. You've seen companies, struggle with that. They've offshored things to India is a real popular place to offshore things. It's a whole nother set of challenges. It's cultural challenges there too. You have to deal with all of that in your governance. Other types of controls. We'll talk more about this too. This is very, very testable, right? They're going to give you specific things and scenarios and then ask you what type of control it is. They call it a tuple. Is that what they call it? Tuple? Is that what they call it when they match two things together? Is that called a tuple? Oh, tuple sounds cooler. So administrative control. So there's our three types of controls, right? Out of our information security definition, administrative, technical, and physical controls. Now the purpose around the control leads to the type of control. Is it meant to prevent a bad thing from happening? That'd be a preventative control. Is it meant to detect something bad that's happening? That's a detective control. Corrective and recovery. The difference between corrective and recovery, if you wanted to kind of just shorten it, corrective is short term. Get the system kind of back up and running. It just corrects the system. Recovery is restoring the system. It's a longer term type of control. Deterrent control, guard dogs is a good deterrent control, right? And cameras are also a good deterrent. Now you can see how a camera can fit into multiple types of control, so it depends on the context, right? Because a camera is a good detective control, potentially if somebody's actually watching the camera. It's also a deterrent control. It's also a compensating control to a corrective control. You see how this kind of, makes I can use what I found on the camera to potentially correct what it is that happened. So understanding how these things all fit together. But
you said you will want to make sure you read the question.
Yeah.
So it'll be using a camera, for example. Which one of those does it fall under? Well, it's going to be in the scenario. So you have to read the scenario, understand what they're looking for, and then say, okay, that's this kind of control.
Yep, that can get confusing pretty quickly. And then compensating control, it just compensates another type of control or another control. Like say a security guard. A security guard prevents bad things from happening. It's a preventive control. They also see things that happen. So they are a detective control. Something's out of place. So a security guard can kind of go across all of these. It kind of depends on what part of the security guard you're talking about, how it applies. Risk analysis. Oh, geez, we're already at time. Okay, I'm going to go fast, and then I'm going to come back to this again on Tuesday just to recap it. So risk analysis is like my favorite part too. So all decisions should be based on risk. Most people don't assess risk well. It's just, even though we do it every single day, every time I come up to a yellow light at an intersection, I do a risk analysis. You don't even realize you do it. It's like, okay, what's the risk of something bad happening if I decide to go through it, or versus me stopping? And you go through a risk analysis. What are the threats? Is there a cop somewhere over here, anywhere? All those things play a role, and people don't really realize that they do that. So, but in order to do a risk analysis, I have to know the assets that I have, threats and vulnerabilities. Now, I'm not a big fan of the definition in the book about risk and what risk is, but that's the definition for the book. Risk is likelihood and impact to me. Threats and vulnerabilities lead to likelihoods and impacts, right? But for the book, a threat times a vulnerability times an impact is a risk, or a threat times a vulnerability, according to the book, is also a risk. Very, very overused. I use a definition a lot, or a scenario. What do you think is more risky? And people always answer it, right? Because you know the context I'm asking the question, but an earthquake in San Francisco or an earthquake in Boston. And if you don't understand the context and you just asked it a different way, a lot of people would say they usually err on the side of likelihood, so they would say an earthquake in San Francisco. But the impact of an earthquake in San Francisco is significantly less than it would be in Boston, right? Because they have building code requirements in California that protect against earthquakes. Whereas in Boston, even though they happen very, very rarely, they have happened before, the impact would be devastating, right? I mean, it would level the town. So when you really combine the two, you could make a case that they're almost equal. So risk calculation, so ways I can do risk analysis, I can calculate a risk, assign metrics, specific metrics to specific characteristics of something. And then based on those metrics and characteristics, I could do a calculation. Risk analysis matrix, somewhat like this. This is what we would call a qualitative risk analysis. Annualized loss expectancy is something that we'll need to know. ALE is annualized loss expectancy. SLE is single loss expectancy. ARO is annual rate of occurrence. So I need to calculate first the single loss expectancy, a single event that happens. How much is it going to cost me? First, I have to know the asset value. So how much is the asset worth as it sits? What's the exposure factor? So what percentage of the asset is unprotected? That's where our control effectiveness comes in FISA. How effective is the control? What is that gap? What's the exposure factor? Single loss expectancy is the asset value times the exposure factor. A single event happens, that's how much I expect it to cost me. The annual rate of occurrence is how often can this thing happen given the current state of things over the course of a year. That will give me my annualized loss expectancy. Now this would come into play. Remember I talked about return on security investment, ROSI. There's no really ROI in information security. There's a return on security investment. In order for me to demonstrate that return on security investment, I'd have to take the annualized loss expectancy as it sits today, take the annualized loss expectancy if I put a control in place, and take the cost of the control, compare the two. The difference is my return on security investment. Does that make sense? You will need to know this calculation for the exam. This will be in there numerous times, I would assume.
They have multiple scenarios that are same, asking different questions. Determine what the ALE is for this, or what is the annual rate of occurrence, or what is the cost of this based on this information.
Right. So you will need to know. You'll need to know how to, so memorize this. In real world, like I said, one time I've actually had to calculate, and I've been in information security for 20 something years, 5 years. I've only had to calculate and demonstrate return on security investment one time. But I can do this because I've freaking given this class so many times, right? So annualized loss expectancy, you'll have to do it for the exam. In real world, I don't know if you'll ever do it. Have you ever done it in real world? Yeah. So risk analysis, total cost of ownership, TCO, and there's our ROSI, return on security investment. Essentially, that's how you create, that is how you calculate it. Annualized loss expectancy with no control, annualized loss expectancy with a control cost. Compare the two. If there's a net positive, meaning I will save money in losses if I put this control in place, that is a return on security investment. Budget metrics, I can't manage what I can't measure. I'm a big metrics guy. You hopefully will become a big metric if you're not already. I like to measure everything. I want to know if I do this, what's going to happen? How does this change things in the environment? That's what I go to get budget for, right? Create scores, put something in place that says the security program, the way it sits today, has this number associated with risk. It's a 6 on a scale of 1 to 10, right? We want to be more probably an 8, right? We use 300 to 850 for the FISA score. So if I add these things to the environment, how's that going to affect my score? If I'm actually going to use that score as a measurement of my security program, right? So it's hard to believe. It's kind of funny because you got budget you get budget a lot without any justification for why I get budget, and something I get no return on investment for. So that's why measurement is very important to me. And I've been asked so many times, in board meetings and executive meetings, hey, Evan, tell me how this is going to make us more money. Okay, right? That's what they're thinking. So I need to justify my budgets. Risk choices. So every time I get a risk, denying that I have a risk is not an option. I have one of 4 options, and be bold with this, and it's the truth. I can either accept the risk as is. That's a legitimate business decision, right? The risk is critical. I'm going to choose to accept it. Fine. I'm a security guy, not the business guy. So if you choose to accept that risk, live with it. I can mitigate or remediate that risk. I can put additional controls in place to reduce that risk to an acceptable level. That's option number 2. Option number 3, I can transfer the risk. I can get some insurance against it, right? So something bad happens, I'm going to offset some of that impact with insurance. Option number 4 is avoid it. Stop doing what it is you're doing. That's it. There's no other options. And so those are fun discussions to have because we have all these risks. Let's talk about them. What are you going to do about it? Well, I don't intend on doing anything about it. Not an option. I guess that means you're accepting them all, potentially, right?
And I was tested on those choices.
You're tested on these choices? Yeah. You should. Yeah, you're not. You
Oh,
are.
you are.
Okay.
Yeah, you are.
And that's good because that's legit. I mean, that's their responsibility, our responsibility, but really at the end of the day, it's the executive. So risk analysis, 2 different types of risk analysis, and I'm almost done, I promise. I'm sorry we're running a little bit late. Qualitative risk analysis and quantitative risk analysis. The difference between the two on a high level, a qualitative risk analysis uses professional opinion, whereas quantitative risk analysis uses hard numbers, uses dollars. Right. So if I were to assign dollar amounts to every one of my assets and I was able to quantify the impact of all these threats and vulnerabilities in terms of dollars, I could do a quantitative risk analysis. A qualitative risk analysis is high, medium, low. You know, in my opinion, this is a critical, you know, and it's that kind of risk analysis. It's not possible to do a fully quantitative security risk analysis of an organization. You can't do it. At least now you can. Maybe someday you'll be able to do it. But man, it'd be great if you could, because then I could go and really demonstrate the return on security investment on everything that I spend. So you can make such great decisions on. So that's a pursuit. That'd be great. But qualitative risk analysis is usually kind of the best that we can do right now in a lot of cases. You know, take this asset, you know, it's got this weakness in it. These are applicable threats. You know, given that, I think the likelihood could potentially be, you know, I don't know, moderate, the impact maybe high. Okay, that calculates into a high risk, right? That's a qualitative risk analysis. Risk management process. So if you like reading NIST special publications, anybody like reading NIST special publications? If you do, these are all freely available. You can go to NIST's website. All the SPs are there. Special publication 800-30 outlines a 9-step process. They're actually pretty good documents. I mean, I like NIST. I don't run security programs based on NIST because I like to make money as a company, right? They're very rigid. The one you'll get familiar with if you get more into this industry will be 800-53. That's kind of the granddaddy. But 800-30 is the risk, you know, management process, 9 steps, and I would sort of memorize these 9 steps. It's a pretty good flow, and it's testable. Types of attackers. So hackers, this is kind of, you probably already know this, but hackers in and of itself are not bad, right? Hackers like to use things and test things to the limits and exceed things and test boundaries, and that's not bad. There's different types of hackers. There's black hats, which are called crackers or malicious hackers. Those guys are bad, and gals. There's white hats, which are ethical hackers. That's us, right? FRSecure we're ethical hackers. We hack when we have permission to. We do it for a specific purpose. It's not to cause damage. It's not to, you know, it's not to steal stuff from you. Gray hats are just confused. I think they have an identity crisis. You know, they're like, well, today I'm black, tomorrow I'm white. I don't know. I don't even know why you'd cut gray hat. You just idiots. You're kind of like, I don't know what I am. At least black hats, even though I don't agree with them, they know what the heck they're doing. You know, but white hats. The difference between these two, there are some distinct differences in how it plays out. Black hats don't care what you think, right? They're not trying to earn your business. They're not trying to keep your business. They don't formulate rules of engagement in statements of work. They go outside. They just don't care. They will whereas ethical hackers won't do that, right? So there's always kind of this area between what a black hat hacker does and a gray hat hacker does. So if you do penetration testing, you're not getting the full picture, right? You're getting a picture of this one thing that you engaged to have this picture of, not what a black hat would see or do. Script kiddies, those are people who use Kali Linux and know how to run some scripts and stuff, and that's about all they do. They don't create tools, they don't create exploits. They use exploits that have already been created for them. There's no skill there. High schoolers do stuff like that. Outsiders versus insiders, obviously those threats are completely different. If you have an insider who's just a malicious insider, good luck. Yeah, I mean, it's probably going to happen something, and I don't know. It's a lot different. It's hard to deal with those kinds of people. And the thing is with malicious insiders too, there's different motivations, right? I may have just fallen on hard times. My house is in foreclosure, man. There's an opportunity here for me to do something. I normally wouldn't do it. I mean, it's different. Outsiders are a lot easier to protect yourself against, right? There's a boundary there. Hacktivists, they do things that they do to make some kind of point. Botnets and bots and botnets, you can go out and buy yourself a herd of botnets for, I don't know what the going rate is, but 5,000 systems for maybe rent them for $100, a few hours to attack a friend or something. But that's legit. They're really, what they're mostly used for is for sending spam. Those are big money makers for spam. Phishers, spear phishing, all that stuff. We're going to talk about more of that stuff later. Vishers, which is, we're just getting silly with names, really. Yeah, it's voice phishing. But phishers are very effective, right? I mean, nowadays we do a lot of our attacks, depending on what the objective is for attacks on internal penetration testing. We will assume that we already have internal access because it's only, I mean, a minimum of 30% of your users are going to fall for one of our phishing attacks and give us a foothold into the system. So do you want to go through that? We'll go through it, but do you just want to forego the expense and just give us internal access and we'll go from there? Most customers now are like, yeah, okay. So phishing is just, it's very difficult to deal with phishing attacks. There are some technologies out there. I even came across one technology that said, go ahead and click. They're selling some kind of something that sandboxes or something. Did you see that? And I was like,
the one with the red button.
no, I'll have to find it for you guys. To me, it's like, it's just a bad habit, whatever. I'm not doing it. All right, so we got through. That's good stuff. Any questions? I'll be here still for a little bit. But read chapter 3, domain 2, asset security. It's a short chapter. We will get through all of that fairly easy on Tuesday. And we will start then digging into chapter 4. So if you want to read into chapter 4, feel free. We'll start, digging into that. There's a quiz at the end of chapter 1. Go ahead and complete that if you want, or if you have time, we will cover that. I was going to create a quiz, but I think that one's a good quiz. Let's go ahead and go through that one. We'll cover it on Tuesday. And come with any questions and any feedback that you have. Like I said, this feedback was really important. Hopefully we did better this week or this day. Any questions? Anything? All right, we're done. Thanks guys for sticking around 15 minutes late. I appreciate it.